full group as much as possible. What I did want to do, because I know I sent out a lot of homework and not everyone got to it, so I'm going to use a little bit of time to pick some of your brains. We're putting a very short pause, a few days, on getting these ideas up on Engage Dora, because I want to make sure we get these framed right. So I would love to get some thoughts on specific points folks think are important for us to make as we're sharing these ideas with the general public. I'm going to start the conversation first around the emotional distress damage ideas that this group has generated. And we're not revisiting the ideas, but I would love some of your thoughts for whether it's an attorney or a business owner or just a member of the general public who is reading these ideas. What are the things that you think it's important that we frame here? Our intention is to include language about the previous legal situation and what the Cummings decision changed. But I would love thoughts on what you think it's important for us to share in as plain a language as possible and as succinctly as possible to help people think through these ideas that we've offered under the emotional distress damages. And if anybody wants me to remind what those ideas are, I'm happy to do a quick readout on it, but would welcome just thoughts on what people think the public needs to know to be able to make some common sense informed feedback for us. Andrew, you know what, Andrew, I apologize. I forgot to do my typical start of meeting administrative stuff. Since we are publicly streamed, we are live streamed and recorded. Let me hit on all of that real quick. This is Barrick Abramson with Confluence Policy and Strategy Group. This is the July 8th meeting of the CADA Rewrite Subcommittee of the 1296 Task Force on the Rights of Coloradans with Disabilities. We are streamed live on YouTube and recorded for later playing. We are doing an extended meeting today of 2 hours to get through a lot of material, unless this group is super efficient and maybe we get through a little faster. We will have opportunity for public comment here at the end. I'm saying that, seeing no members of the public on our screen, but folks may be watching on YouTube or listening in other ways. Just as some reminders, we ask everyone to avoid using the chat unless you need to send me or Carrie an urgent message, simply because it can be distracting and is not always accessible to all members and participants. And also, I'm going to ask that folks remind folks who they are when they speak. With that, Andrew, I appreciate your patience. Let's go into some conversation about what kind of context and framing we think is important as we start to share these ideas out. First, we'll talk through for 5 or 10 minutes on the emotional distress damages.
Thank you, Barrick. This is Andrew. Just to start off with, I'm probably going to be a little more off camera today than usual. I'm just feeling a little under the weather. In any case, one thing that I think might be helpful for the general public to know is that prior to the, I want to say 2015 amendments to CADA, the part that inserted Section 802 and 803 for service animals, prior to that and the change in language that caused, emotional distress damages were in fact available under CADA. So separate and apart from Cummings, emotional distress damages used to be available under CADA. So I think that might be helpful for the public as well.
I appreciate you naming that. Thank you, Andrew. Others, as you think through from either an attorney's lens, somebody with lived experience, a small business owner, folks looking at this, what do you think, if they haven't been part of our conversations, we need to, in a one paragraph or a series of bullets, offer some explanation? Ian.
Thanks, Barrett. Ian Calmano. I guess I'll just preface briefly. I mentioned to you and Terry in an email this morning, I'll be gone at noon for a brief phone call. I apologize for that. As far as framing goes, Andrew's comment about the 2015 changes to CADA, did flag for me that up until 2015, emotional distress damages were not available for employment claims under CADA. Those did not go into effect. They were added in 2013, but they didn't go into effect until 2015. One of the things I think in terms of framing, though, is I think it's important for the public to know, for other lawyers, business owners, individuals to know, frankly, the law discriminates against people with disabilities. Right? We have now, this law is set up in a way that people with disabilities are not eligible to obtain the same relief for discrimination that, in public accommodation, in housing, that people with, people who are a designated racial minority, for example, would be able to obtain. If a black man is denied service at a public business, he can bring a lawsuit under various other statutes that would enable him to recover emotional distress damages. If a Hispanic woman is denied housing or a pregnant mother is denied housing, they can bring those claims and obtain those damages. And I think it's important to just let the public know that these remedies are different based on the place in which the discrimination occurs, and different based on who is the victim of discrimination. And that shouldn't be the case.
I think that brings some clarity that there's a protected class that is not protected in certain locations and situations. So I appreciate you naming that. Anything else folks would want to include? And I would love people's thoughts. Some people had emailed asking whether we might include an example of this is the type of situation we're talking about. My hesitancy there has been in defining what is and is not grounds for emotional distress. And maybe the lawyers want to offer some thoughts, maybe others want to offer some ideas of where we could give a high-level example, and we need to phrase it in might give grounds for these claims. But is that relevant to people being able to wrap their head around, if they're not an attorney, haven't been either the claimant or the respondent, on what we're even talking about when we say emotional distress damages, and open it to the floor for thoughts on what we should offer around that. Alana, I'm going to pick on you as not one of my active attorneys. If you were to say to your neighbor, we're talking about emotional distress damages for discrimination, is that plain language enough that you think people understand what we're talking about, or do we need to offer these are the types of claims some people have filed and sought emotional distress damages?
Yeah, this is Alana. I think for me, it feels like one of those things where you know it when you see it, and I know there's a famous quote around that I can't quite pull up today. That I do kind of agree that my concern with listing specific examples, I love examples, I'm a data nerd, but my concern there is that then becomes the list of options, and if it's not in one of those examples, it must not be emotional distress. And I'm sure the actual lawyers have strong thoughts one way or the other on if that's a real risk or not, but that's just kind of where my mind immediately goes with that.
I appreciate it. And that's been my concern, is me as a facilitator trying to describe a legal term. I believe the quote you're thinking of speaks to obscenities, so I'm probably not going to go there with our examples. Ian or Andrew, do either of you have thoughts, or am I overthinking this and people, to Alana's point, know what we're talking about? Ian, jump in.
This is Ian. I'll jump in. No, I don't think this is overblown. I do think it's important because I'll admit this, right? When I started practicing law and started practicing in this area, I didn't really understand the concept of emotional distress until I actually started talking to my clients about the way these things impacted them. And so knowing that and having lived that, as a new lawyer, albeit a number of years ago, I do think it's helpful to talk about this. Examples are hard because, part of the problem with this is that how this impacts each individual is different based on the individual. And so to give an example, I fear in some instances can set us up for, a negative consequence, in that we're giving an example that may resonate with us on the committee, but not resonate with the community at large. One of the things that I just pulled this up, in order to sort of guide my thoughts. The federal statute that talked about the emotional distress damages awards in the context of employment discrimination talked about damages awarded for emotional pain, suffering, inconvenience, mental anguish, loss of enjoyment of life, and other non-pecuniary loss. And, and so the non-pecuniary part, I think, needlessly complicates things, because what the heck does that even mean? But, there's more to this than just calling it emotional distress. That's sort of the shorthand that we all use rather than list all this off. But I really do think that, from my perspective, we do need to be talking about this in terms of the dignitary harm that people suffer, right? Like, that's what this is really all about. It's your individual dignity and how that's damaged when you're denied access, when you're deprived of a service, when you're asked to leave a restaurant or a public space, when you can't get into a restaurant or a public space, when, all of those things impact people on a visceral level. And, I feel like we just need to be talking about that specifically. And we can use these other words, right? Like, it's not just emotional distress, it's loss of enjoyment of life, right? The example that's been I think defeated a number of times is your inability to watch your kid graduate from high school, or your inability to watch your kids, orchestra performance. How does that impact you? And I think that we run up against this sort of negative messaging that has been going on for decades now about, people who file lawsuits. And people file lawsuits because they're just out for a quick buck. And, there's always those examples. I know the hot coffee case has come up during our meetings in the past as well. And the way that woman was vilified for bringing that claim. I think we need to have these dialogues so people understand what this is really about. So I know I didn't give you any concrete or specific examples there.
And I think you are highlighting the challenge. And maybe, as I'm listening, maybe one of the things we need to do is invite people, in addition to the questions we're asking, to share their stories or experience and their take on this. I still remain hesitant to say this is what it causes. I'm wondering, I'm looking at Cornell Law, who offers their definition as emotional distress refers to mental suffering as an emotional response to an experience arising from the effect or memory of an event, occurrence, pattern, or events or conditions. And it goes on to say that in tort law, there are two causes of it: action, intentional infliction, and negligent infliction. I'm going to ask two different questions, and I'm doing this, they're disjointed, but I think it's important to maintain balance in what we put out there. Do we want to try to find an example definition with clear language that we're not citing this as Colorado's definition, but as an example to be considered? And then I also want to ask folks to think, what do we need to do in our framing to help understand or prod people to think about what are the implications on both sides of what we're recommending for claimants or for a respondent business? Andrew, please.
Thank you, Barrick. This is Andrew. I think defining what emotional distress damages are, or the broader words and phrases Ian cited, I think that would be beneficial to make sure that folks know what we're talking about. But I too share your concerns about providing examples, because I think those examples could significantly weight whatever results we get, just depending on how we state them. And I think it would be nearly impossible to draft a neutral example sufficient to let folks know what we're talking about. I mean, I think folks, kind of like Alana said, know discrimination when they see it, and kind of understand what emotional distress damages are.
So is there anyone who would have a concern with the framing, including an example definition of emotional distress, but not including any examples of this would be, this wouldn't be, or this might be. Please.
This is Ian. Thanks, Barrett. I have no problem with the idea of a definition that provides, more clarity or more detail as to the kinds of things that are emotional distress. I have a problem with the idea of examples of this is and this is not, because again, that really ignores the fact that, in the law, you take your plaintiff as you find them. And, what will have an impact on one person is going to vary greatly from another person. Two people who look the same are going to be impacted differently based on their own experiences, their own past, things that have happened to them before, where they are in their life when things happen. And I think providing examples of this is, this is and this is not, are not necessarily the kinds of things that are, they're helpful in a discussion like this among a group, but I don't think they're helpful in a document that would be circulated around. I can say that, I've had clients that have had dramatic weight loss because of the emotional distress that they've suffered because of discrimination. And a lot of people might hear that and say, well, I could stand to lose a bunch of weight. How did that have, a negative impact on you? I've had clients that have had dramatic weight gain, as a result of it. People who sleep too much, people who don't sleep enough. That's why I just don't think that the examples can necessarily be helpful, because it really is just so unique to the individual. But I do think providing more guidance in terms of what we're talking about when we're talking about emotional distress, and not just using the legal definitions, or, from the law dictionaries or from other statutes, but really, getting into it and explaining what this is. And I think we can do that.
Okay. I appreciate that. I think we're aligned on this. Ian and Andrew, I may reach out to you offline and bounce some ideas. I want to switch or perspective on these recommendations entirely. We're kind of looking at what might give grounds for a claimant. Do we need to give any framing for what the implications are for a respondent, for, let's name it, for a potentially an accused business? Or is this, as Alana has suggested, it's obvious that the implications for a business are you could get sued for money and you could lose? Do I need to spell that out, or do we expect some level of basic rationality? And I'm not saying that to be dismissive. I have an obligation to make sure we're balanced. I'm not used to this crowd being this quiet. Ian, jump in, and soon
this is Ian. I don't want to dominate the conversation at all. I will tell you that based on my past experiences working on legislation to what I would call expand employee rights under CADA, it doesn't matter whether we say something or not with respect to the business side of it, because this is my own personal belief that they're going to be against it. I recognize that. I accept that. I have a very simple response to, the idea of a business being against adding emotional distress damages to public accommodation discrimination, and it's don't discriminate in places of public accommodation. If you don't discriminate, you're not going to get sued. I don't know what we could do. If you can figure out, or if we as a committee can figure out what we can do in that messaging, I think we will have found the secret sauce. Because I say this, and again, not to denigrate the business community in any way, But every time there is a discussion about an expansion of rights in this area, they're opposed to it. And I mean, I can understand, you know, the business reasons to be opposed to it, but I also can understand the business reasons to not discriminate against people.
Yeah. And on that note, and then Cindy, I'm going to bring you in. You know, I want to be very direct about two things. This task force and this legislation were not passed to see if we cannot change things.
Right.
They were passed to say, what do we need to change to better protect the rights of Coloradans with disabilities? On the other point about business opposition, I will both recognize that as a likelihood and acknowledge that is probably an appropriate role for executives whose job is to protect whether it's shareholders or their own bottom line. And I think that's where we have to look at what is the charge of this task force and recognize we're not going to put forward things that everybody is going to love, and for some it's not going to be enough. In a minute, I'm going to switch to some other terms, but Cindy, did you want to weigh in on this and what we do need to frame here?
Yeah, this is Cindy. And I guess I just want to share my opinion that I don't think that the majority of folks who will look at this from the public will understand this unless we give a little bit of framework about the process as well as some examples. So, you know, even if it's a diagram of, you know, the steps that occur in the process when filing this type of a complaint, if you will, so that people know, well, where are we when we're talking about emotional distress? Because most folks are going to think that's a big part of the hearing and not later down the road. And so I think we need to identify the process and where this decision has impact in the process. And then I think we need to give some framework as to the different types of situations that we are referring to. So we're not just talking about employment is one, but we're also talking about public accommodations and so forth. So in my opinion, we've got to do some work to make this easy enough to understand, and then examples more of this is what it looks like today, and if you go through this process, this is the outcome as the law is now, and then this is the potential change if we change this, because otherwise I don't think people are going to understand it all.
I appreciate that, Cindy, and I'll work with Carrie and we'll come up with some examples like that, because I think you're right that if we get to, was there emotional distress as a result of this current situation, sorry, proposed solution, right to litigate that. And I'm oversimplifying, but we'll work on some examples of that. I'm going to complicate it even more. One of our recommendations, and this is the byproduct of me listening to a lot of lawyers and being a policy wonk myself and the son of a lawyer, we end up with a recommendation that talks about further amending to allow plaintiffs to seek and recover additional punitive damages if affirmative intent to violate the underlying statute is proven to the appropriate standard by plaintiff. I'm going to go out on a limb and say 50% plus are going to be lost halfway through that.
Absolutely.
I can work on the language itself, but there is, as Andrew and Ian have frequently reminded, and as my father would anytime I told him to simplify one of my contracts, there are legal terms of art that we do have to include when we're talking about punitive damages or affirmative intent. So I would love thoughts on how we talk about either of those legal terms and break it down in a way that becomes really accessible. Ian, jump right in.
This is Ian. I think one of the ways we do it is we look to the jury instructions that we use in these cases, because those are supposed to be written to explain complicated legal concepts to lay people serving as jurors. And so for punitive damages, I frankly think it's a little bit easier than the emotional distress damages, because the purpose of punitive damages is to punish somebody for their wrongdoing. And we don't punish somebody because of an innocent mistake. We punish somebody because they acted, they knew they were violating the law, or they should have known they were violating the law and they did it anyway. And that is a one simple way of getting to the heart of punitive damages, right? These damages are intended to send a message to the community at large that, as a society, we don't accept this kind of conduct. You all have an obligation to abide by these rules. And when you go outside them intentionally or knowingly, we're going to punish you for it. It's a lot easier to do punitive damages, I think, than
I appreciate that. And I see Rep Ortiz has joined us. So everyone knows what the exec committee decided was the exec committee members. And I see Mr. Stone is with us as well. Are probably going to be dropping in on a lot of these calls. We're going to invite them kind of at the start, at the midway, and at the end to offer thoughts they want us to consider. Rep Ortiz, just so you know, what we're doing is we're reviewing the ideas generated to date and just getting input from the group on what context we need to make sure we include to frame these when we go to the public for feedback, to make sure we're not taking really overly complicated language that people will not be able to easily access what it is we're asking for the feedback on. And we've been talking through emotional distress so far. Before I move us to our next set, which was around exhaustion and the process, anybody else want to offer thoughts that you think are important for us to include in framing or offering background for the public when we're talking about the emotional distress damages, both the right to pursue, as Cindy's talked about, the different situations we're talking about, and as we've just talked about, things like punitive damages and intent. Any other thoughts that you think are important to include?
I've got one before I jump onto this call and then come back. And this is just, again, I'm sorry, this is Ian. Nothing that we're proposing here is new. Okay, nothing that we're proposing is new. And we talk about how, the ADA has been around now for, 34 years, but anti-discrimination law has been around a lot longer than that. The Civil Rights Act was passed in 1967, but we have Civil Rights Acts going back to Reconstruction after the Civil War. So we're talking about stuff that's 120 years old, right? We're not talking about new concepts, more than 120 years old. I'm sorry, I'm just bad at math. But we're not talking about new concepts here, right? We're not talking about new ideas. We're not talking about creating some sort of new laws that are going to upend, existing business, existing, government, existing public service. We're talking about stuff that's been on the books for generations. And we're just bringing it all into line and cleaning it up. And I think it's really important that we let people know that. We're not adding a new protected status here, right? That's what the Rehab Act did. And that was in the 70s. That predated the ADA by 20 years. We're not creating new protected statuses. We're just cleaning up, the crazy quilt of all these laws. So I'll leave you with that. I'll be back as soon as my other call ends. I apologize for that inconvenience.
We appreciate you, Ian. Let me go ahead and shift us. And this one may be a shorter conversation, and then we'll start digging into damage caps, modernizing dollars, and we'll begin the public accommodation laws discussion of ideas. On our ideas for exhaustion and timelines, right now we've got two ideas we intend to share. One is to amend Colorado revised statutes to remove the requirement for exhausting administrative remedies where it exists relating to claims for discrimination while preserving the right. So we're making it optional to pursue that. And then this group also has suggested amending statutes relating to timeline or statute of limitations and making it 3 years for any claim of any discrimination by an individual with a disability relating to housing, employment, or by or against a public entity or relating to a public accommodation. So we've just got the two. One is removing the requirement to exhaust administrative remedies, but leaving the option. The second is to really standardize at 3 years the timeline or statute of limitations. Other than noting that there currently is a requirement and that there currently are different timelines. Are there additional contexts or backgrounds that you all would think are important for the public to be able to understand the basis or the conditions of these recommendations or ideas? Andrew. Yeah, please, Andrew, jump in.
Thank you, Barrick. This is Andrew. Just to again highlight that, as far as public entities and public businesses, public accommodations go, there is no exhaustion requirement currently. So I want to make sure that that's made clear to folks and that we start with that as the baseline. Well, I understand that there are exhaustion requirements for employment and housing, and I fully support the recommendations that we make those optional rather than mandatory. I want to make sure that we're clear on that, both moving forward within our group and with the public, so that folks don't think that we're trying to pull a fast one essentially, and roll back the work that we've done a couple of sessions ago to get that clarified.
Appreciate it. So get clear about current conditions and what we are changing. Anyone else on this? Okay, then I'm going to move us into new discussions. Carrie and I will work. We'll take all of this. I'll probably follow up with a few of you on language with the goal of getting these ideas up Monday or Tuesday to start circulating. I want to make sure we get this language right. And frankly, this committee is probably the most nuanced for getting the language right. So I want to put that time, but we'll spend the appropriate time with these available for stakeholder input. We have 3 topics that we're going to go into today. I do want to forewarn, since we asked for 2 hours, I am going to build in a 5 to 7 minute break. And if you need to take a break, otherwise, please feel free to do so. Don't feel locked to your keyboard or your screen. Our 3 topics, the first 2 are damage caps and modernizing dollars. Depending on where we get with those, we will begin the discussion of public accommodation laws. I will flag, we've had some members of the exec committee bring to us some additional situations, particularly relating to public accommodations. So we're going to have some guests join us at our next meeting to share some experiences that they would like this group to consider addressing. But before I start the group conversation, I want to invite Representative Ortiz and Michael Stone to offer any thoughts or ideas you would like this group thinking about as we go into this conversation about damage caps and modernizing dollars, or if you want to reflect on the conversation we just had about the framing of the other ideas being floated. Michael, I see you off camera, or on camera, excuse me. So I will bring you in first if you'd like to offer thoughts.
I just did that just to be polite. Michael Stone speaking, everybody. I honestly just wanted to say thank you. I don't want to do anything to disrupt the flow of this meeting. I'm absolutely loving it personally, and it's absolutely incredible. I do have some questions, and that I might just formulate through Barrick, and not in the spirit of not disrupting any of the flow that you guys are doing. You guys have this, and I'll turn that over to Rep Ortiz.
Thank you, Michael.
Thanks. This is Rep Ortiz. No additions. This subcommittee is pretty stellar and pretty spot on with its discussion. So I've got nothing to contribute at this time.
Thank you, Representative, and thank you, Michael. So with that, I will move us into what we have done in our past, which is an open ideation session for ideas around, in this case, we're going to combine both damage caps and modernizing dollars. And I want to invite, again, just as a reminder, these aren't proposals, these aren't recommendations. We're not here to vote, to love, to hate. These are ideas that you think are worthy of gauging public stakeholder reaction to it and getting their specific thoughts around the details. Andrew, your hand is up. You're in first.
Thank you, Barrick. I actually wanted to do 2 things. One is suggest that we maybe wait for this, first set of topics until Ian gets back for 2 reasons. One, my area of expertise is not in employment law, and I know that's where damage caps and modernizing dollars really sound a lot more so than in the public accommodation and public entity realms where there has not been a cap. So, for that reason, I think waiting for Ian to return might make a little bit more sense. The second thing I wanted to do was to clarify when we're talking about public accommodations laws, what it is we're talking about. I have something I'd like to discuss, but I just don't know if it would fit into that heading, so to speak.
Unless I have objection from the members, why don't we put caps and modernizing on hold? I'll turn my agenda upside down and go into public accommodation. And with that, Andrew, give you the floor.
Thank you, Barrick. Again, I'm not sure if this fits within the, and this is Andrew Montoya. I'm not sure if this fits within the parameters of this topic, but last week, the Supreme Court issued another decision that is essentially going to, has the potential to, and I think likely will, turn a lot of the ADA on its head. It was the Loper-Bright decision, and essentially what that did is it overturned what was called the Chevron doctrine. Under the Chevron doctrine, federal agencies were empowered to come up with what the law meant. Essentially, Congress would pass a law like, say, the Clean Air Act, for example. Now, Congress didn't go in and write in the law what parts per million were acceptable pollutants, for example. They left that up to the EPA, and the EPA filled that gap. And essentially, the Chevron doctrine said that courts, in interpreting these statutes, need to give deference to these agencies when they come up with permissible constructions of the statute, and these gaps exist. The Supreme Court, and I'm sorry, that Chevron case goes back 20, 30 years at this point, and I mean, that's been a bedrock principle of administrative law. That comes into the ADA because when Congress overturned that decision and essentially said we're explicitly overturning Chevron, that undercuts the ADA, particularly Title II of the ADA, because a lot of the meat of the ADA comes from the regulations and the standards promulgated by the Department of Justice or the Department of Transportation. And under Loper-Bright at this point, those agency interpretations, a judge could look at them and say, I like them or I don't like them. But that's really where we get things like the design standards talking about an accessible route should be 36 inches. And sure, it can narrow up to 34 inches for particular areas. Or a doorway should be, 36 inches. All of really, again, the meat, and particularly with respect to Title II, which is government entities, public entities, the statutory text itself is so small you could probably print the whole thing on a single sheet of paper. All of the meat for Title II comes from the regulations. And if you go back to some of our earlier meetings, one of the things I'd recommended us doing is incorporating things like those 2010 standards for accessible design into Colorado law. That Supreme Court case makes that all the more critical. So I just want to make sure that is something that we are looking at doing and raise for everyone, that what was a potential has now become a reality, that Chevron is gone, and therefore deference to those agency interpretations potentially is gone as well.
Andrew, if you're okay with it, I'd like to ask the group if they have questions, because I agree those were some big cases, and I don't know that everyone has been tracking closely. Does anyone have questions about either of the cases that Andrew raised and the implications of us having relied on regulation in an environment where the Supreme Court ruling directly affects those? So, Andrew, what I want to do is see if there's questions about that, and then come back to you if you have a specific idea, such as incorporating those standards or regulations. But first, do members of the committee have questions about those rulings, understanding I am far from a lawyer, so we'll be looking to Andrew for right now. Are people familiar with it? Were folks familiar with the case and the cases and what it, particularly Chevron, means with the Supreme Court's ruling? Alana, jump in, please.
So I have been trying to follow all of that. There's been a lot of updates from the Supreme Court, so I don't know that I've caught everything. But I guess just to make sure that I understand what I think I do, I would like to try explaining it back. And then you can correct me if I'm going wildly in the wrong direction or anything. But my understanding with the impacts of the Chevron removal is that if someone, I guess, sued saying this is not accessible because it's public accommodation, right? What previously would have happened is they'd be able to point back to what the ADA said, and basically say, hey, the standards are 34 to 36 inches. This is 33 inches. Standards say this doesn't work. But the new policy is the judge could choose to say this is what the ADA says, or the judge could say, I don't think the ADA has it right in this scenario, so I'm going to ignore that and go by my gut feeling, which is that 33 inches should be totally accessible. Is that a correct understanding of the basically impact of that?
Andrew, I'm going to ask you to offer your thoughts. And again, this is not the group having a legal opinion, but Andrew, as an attorney, your thoughts on this question of what it means for the legal process, as she's asked about what a judge could or couldn't do, but also what the ruling's implications are for the ability of a regulatory agency or any agency to enact regulations outside of or in furtherance of a law that was passed.
Sure. Thank you, Barrick. This is Andrew. So Alana, I think that's more or less accurate. A judge, the 36, 32 inches, things like that don't come from the statute of the text itself. And in overturning Chevron, essentially what the court decided is that judges' job is to interpret the law. So you look at the statute and you decide what that means. So with respect to Title II of the ADA, for example, the 32 and 36 inches don't appear in the statutory text. It says that a public entity shall not discriminate against people with disabilities. And honestly, that's more or less it. I mean, it is really short on verbiage. In contrast, even to Title III of the ADA, which goes into a lot more detail about, in the statute itself, as to what constitutes discrimination. So in that sort of a case, a judge could look at that and say, well, this person's wheelchair is really only, 32 and a half inches. So technically they can make it through that 33-inch doorway or that 33-inch pathway. Therefore, it is accessible to that person. And yeah, that's the end of it. That would not constitute discrimination under the ADA. I think it's kind of a slightly separate question what Barrick posed as far as going forward with respect to agencies promulgating new regulations. There's nothing in that decision or anything that's changed that says agencies cannot promulgate regulations and other standards. What it comes down to is the deference that courts are required essentially to pay to what those agencies say. So, for example, the 2010 standards have gone through the Access Board, which it's composed of people with disabilities and others throughout the nation who get together, much like we are here, and come up with what these standards should be, down to literally the inch of what constitutes access. And so a judge could look at that. Or I'm sorry, moving forward, the agencies could still promulgate these sorts of regulations with all of that expertise, but a reviewing court could look at that and say, well, I feel differently, or well, the facts of this case bear out differently because this person's wheelchair is only 31 and a half inches wide, so 32 inches works for that individual. Yeah, and I'll be completely honest with you too. The fallout of this decision, I think, will be vast across many realms of law, and we're still kind of grappling with what it may mean, broadly and particularly with disability rights. So it may be that there are huge seismic shifts. It may be that really it's just a matter of adding another couple of lines to convince the judge that all of this agency expertise really should be given deference. But ultimately, the problem is that it's still up to each individual judge. So we no longer have the benefit of the uniform rule throughout the state or even throughout the nation. Each individual judge will get to make up his or her own mind as to what actually constitutes, accessibility or discrimination. Kind of going back to some of our discussion earlier, and your obscene example, you kind of know it when you see it. Each judge sees things differently, and that I think will cause a lot of havoc moving forward as well.
Thank you, Andrew. I'm going to come back to you in just a minute to probe you a little bit on ideas and whether it's about incorporating specific standards or existing regulations into statute, or whether it's about incorporating by reference different activities or acts of regulatory agencies. First, I want to make sure I check in with Tom Aker and then with Cindy on this conversation. And I want to make sure we're all tracking why we're talking a little differently than we were even a few weeks ago. Tom? Tom, your audio is not working, even though you unmuted yourself. Tom, if it's okay, I'm going to come back to you in just a second. Let me get Cindy in here and see if Tom can sort out that audio.
Okay. So this is Cindy, and like Alana, I'm just going to check in to make sure that I'm understanding what I think I'm understanding. So just taking the example of housing, for example, the Fair Housing Authority, they have all sorts of regulations around what is accessible, what is not accessible. There's different guidelines. I think they refer to them as safe harbors and so forth. So they have these sets of guidelines. And if I'm understanding this right, if someone were to file a complaint about discrimination, the judge wouldn't necessarily defer to one of those safe harbors that perhaps the contractor was using whenever they, built or rehabilitated a particular property. They could essentially choose their own reference about what they thought was or was not discrimination. Is that correct? It doesn't necessarily matter what the Fair Housing Authority has established.
Thank you, Cindy. This is Andrew. I believe so. Let me preface by saying I'm not nearly as well versed in the statutory text versus the regulatory text when it comes to the Fair Housing Act. To the extent that the exceptions that you're talking about or the standards that you're talking about come from the regulations from HUD, for example, as opposed to from the actual Fair Housing Act statutory text itself, then yes, each judge would essentially be able to make up their mind how much attention they wanted to pay to the HUD regulations or exceptions. And it could frankly cut both ways. It could be that, there is a safe harbor that says if you, if you've done X, Y, and Z, then you don't have to comply with this other section. And the judge could say, no, that's no longer the case. You still have to comply with the other section. Or a judge could say, well, even though the standards say that you, I don't know, have to have an elevator, I'm going to say that you don't have to have an elevator because, well, that's not how I read the law, or that's not what the facts of this case bear out, or whatever the case may be. So it is a bit of a double-edged sword, but I'll be completely honest. I see it falling most harshly on the affirmative regulations that exist for people with disabilities, as opposed to some of those safe harbors or exceptions.
Okay, thank you.
Absolutely.
Thank you both. Tom Aker, did we get audio sorted, do we think? No? Okay, this is the one place where I'll make an exception. Feel free to use it. Chat me directly if you have questions or thoughts you want to weigh in, and I'll read those out. Andrew, let me now come back to you. Given what we've just discussed, Ian, welcome back. We decided to hold off on damage caps and modernizing dollars until you were back, since it's more of your area. We're talking about public accommodation laws, and in particular, we're getting into with the Supreme Court ruling and the Chevron ruling, in particular, what that may mean. We may want to float as ideas when it comes to incorporating into law rather than relying on agency regulations or guidance. Andrew had brought up some different examples. And so, Ian, let me just first pause and see if you want to weigh in or offer thoughts on the decisions at hand and their implications for the rights of Coloradans with disabilities.
Yeah, thanks, Greg. This is Ian. I'm glad I'm back. I tend to think that it would be good for us to put as much into law and be as specific as possible in putting things into law to avoid not just a quote Chevron problem, in terms of getting, deference to agency interpretation, things of that nature, Certainly, we don't know what the Colorado Supreme Court will do with respect to that sort of ruling at the state level. The Colorado Supreme Court at the state level doesn't necessarily have to follow the U.S. Supreme Court in terms of what deference state agencies should be granted. But more importantly, from my perspective, putting it into the law eliminates the possibility of administration changes leading to changes in regulation. And, or changes in interpretation, changes in enforcement. The bump stock case that some people might be familiar with is a really good example of how nothing changed but the administration, and the interpretation of the law changed, from one administration to another. I would really like it if we're done with this and we're done with it, and we don't have to worry that a new governor or new head of the Civil Rights Division or DORA may issue different interpretations or want to change regulations. So I do think that the more stuff we can incorporate into the statute, the better. But I also think that it is good that we're even paying attention to this, because this has the prospect of creating a minefield that we might not have even been aware of if we weren't paying attention to it.
Thank you, Ian. Here's what I'm going to propose to the group, but tell me if, particularly our legal experts, if this makes sense. The intent had been to really dig into damage caps and modernizing dollars. We wanted to make sure that Ian was part of that. I think we've got an important conversation happening here, and I'm wondering if we can't separate out this. Public accommodations is going to extend into our next meeting, I would expect. It's a very broad issue that you all have identified a number of issues within, but this particular issue of the implication of these rulings and what that means for whether it's the judge giving deference or what we're incorporating into law, I'd like to work through that piece of the public accommodations conversation now, and then maybe come back to broader public accommodations. Does that work for our members? I'm getting general nods and thumbs up. So, Andrew, I'm going to go to you first, and then I want to make sure I get everyone in, but simply because you went there first, which means I get to go to you first. It seems there is a large spectrum of approaches this group could put to the public and that the state could take, from statutory language that calls for or even demands deference to regulatory agencies and guidance, to direct incorporation of their regulations upon enactment into law, or us actually taking what exists and incorporating it into law. And I'm wondering what ideas you want to put forward before this group and potentially to stakeholders of how we may want the state to act in this environment after these Supreme Court rulings when it comes to judicial deference and when it comes to direct incorporation.
Thank you, Barrick. This is Andrew. When it comes to judicial deference, I'm not sure that we need a whole lot in state law with respect to that. Colorado is not necessarily bound by the Supreme Court's decision, but the danger is that the Supreme Court's decision is going to make it so that those standards that exist would not necessarily be. I'm saying this in a weird way. I apologize. So I think ultimately what we should do is incorporate things like those standards and the regulatory interpretations into either state statutory law or state regulatory law. With respect to Ian's point earlier, I have no qualms with doing so in statute, and I think that does kind of solidify it a lot more. And I'm also not super familiar with how robust Colorado's rulemaking process is. But essentially, what I would like to see is those federal protections, those federal interpretations put into state law in one way or another, so that should the head of an agency change, should suddenly we have a change in administration who decides that we need to get rid of more regulations, and those are put on the chopping block, those would in fact be codified in some way in state law or state regulations.
I'm going to ask a follow-up question and recognize we may need to come back to this at our next meeting and I'll dig into it a bit. Are there specific sets of regulations or state adopted codes that you would like to put on the table for direct incorporation? And are we looking at doing so as of a date certain? Is it the codes and regulations as of July 8th, 2024, or is it as amended and adopted by these agencies?
So this is Andrew again. To answer the first question, yes, and I can give you half of those citations off the top of my head. There are a couple of Access Board citations that I can only give you the first part of, but essentially 28 Code of Federal Regulations, parts 35 and 36 are the bulk of the ADA standards for public accommodations and public entities. There are a couple of things under Title 36 of the Code of Federal Regulations, some of those other Access Board standards that I'd have to look up the exact sections or parts, and I'm happy to do so and get those to you. But yeah, that would ultimately be my suggestion, is more or less copying those, copy and pasting into Colorado law. I think doing so as of a date certain may make the most sense, so that if another federal agency or federal administration comes in and changes things in a way that Colorado doesn't like, we're not bound to that. But if they change things in a way that Colorado does like, then we can, of course, amend Colorado law to reflect those additional changes. But we, wouldn't be stuck if something happens that's terribly unfriendly to people with disabilities at a federal level. I think that would be perfectly fine and acceptable also, because federal regulations take years, if not decades, to work their way through the system. It starts with an agency promulgating a potential rule. It goes out for notice and comment. Agency may make some additional changes. So to the extent that we are talking about any substantive changes, as opposed to simply just saying, oh, this regulation doesn't exist anymore because it's been rescinded by executive order, those more substantive changes, we're going to have plenty of notice that they're happening and plenty of opportunity to decide what we want to do. So I think a date certain makes the most sense.
Thank you, Andrew. And I will follow up with you for some of those. I think this is one we will continue, so I don't want anyone to feel pressured that you have to name every regulation you want incorporated on today's call, or we won't share that with the public. We'll take a break in just a couple of minutes since we're doing a 2-hour meeting. But does anybody have questions about what's being bantered about here of Colorado incorporating regulations as of a specific date into Colorado law to ensure that they're directly in the law rather than regulation? And to Andrew's point, that we don't incorporate simply by reference, which could lead to us incorporating regs that are watered down or changed down the road. Does anybody have questions or want to add to this idea? Ian.
Thanks, Eric. This is Ian. One other thought that I have that we may want to consider would be that we in addition to adding specific regulations into the statute, simply codifying them, we absolutely could include language that would codify the Chevron deference that existed before the Loper Bright case from 2 weeks ago. And, we could put something in the statute basically that said, it could be as simple as, any interpretation of any of this statute is governed by, the Supreme Court decision in Chevron versus National Defense Council, and not by subsequent decisions repudiating that. I mean, we can make it that simple that we're codifying Chevron deference into the CADA for purposes of the Civil Rights Division's interpretation of the statute, if that's what we wanted to.
Anybody have questions about what Ian is suggesting here? And again, I'm not asking for people to vote on recommendations, but ideas that we are percolating, that we will refine in a subsequent conversation around public accommodations. I'm not hearing or seeing any questions. What I'm going to do, because we did ask you to join for 2 hours, is give everyone a 5-minute break. We'll come back. It's 12:31 by my clock. We'll come back at 12:36 and we'll shift gears entirely to damage caps and modernizing dollars. At which point I'll take a midway break and again invite Mr. Stone and Representative Ortiz to offer any thoughts as we start those conversations if they'd like to. But we'll be back at 12:36 to continue those. For those back at their computer, but currently not on camera, we will start in about 90 seconds. My clock reads 12:36. I'll give a little leeway for folks to get back here. And maybe I was at the very beginning or end of the minute, but we will get going here in the next 30 to 60 seconds. All right, it looks like we have our members back. I appreciate that quick turn. I just want to make sure we got a break. Representative Ortiz, as this group gets ready to talk about potential changes to CADA around damage caps and modernizing dollars, is there anything you want to offer for the group to be thinking about?
No, I think this group brought up a really good point with the Chevron being done away with. I think that is a huge issue that community with a disability needs to start thinking about. And we need to decide here in the state how we're still going to protect and secure some of the basic rights and basic access that have been already secured. I mean, I can think of one law that was passed last year where we're depending on the Department of Justice around EV charging stations. And now we're going to have to go back and amend that law because we were making that law based on a world where Chevron wasn't thrown out, right? Like this is one of the biggest issues I think that a lot of disability rights advocates are talking about. And I feel like this falls squarely in this subcommittee's purview to talk about and to come up with solutions to recommend for the executive committee. So I've got nothing to add on damages. I think we've got some professional minds with some good ideas and that can bring the technical language in. But I know that's an area that I just mentioned is going to be one that's concerning community living with a disability.
Thank you, Representative Ortiz. I couldn't agree more. And it's one of the reasons that I wanted to make sure this public accommodation laws, we don't try to rush it and pack it in with some other things. Andrew, I'm so glad that you brought that issue up and the cases today. I think we need to start looking at every recommendation and idea you all are looking at through that lens. We'll be encouraging the other committees to be doing the same. And as Rep Ortiz noted, I think this is not just an issue for the disabilities community. I think a whole lot of laws that rely on particularly federal regulations, but any are going to have to be revisiting. It's one of those things that in the noise of a presidential election, what may be one of the more tectonic shifts in legal precedent is not getting quite the attention that maybe it should. So Andrew, thank you again for putting it forefront here. We'll continue to make it one of the lenses through which we view any of our ideas that we're putting forward. With that, let's talk about damage caps. And I will just ground us that we had a conversation strictly about caps on emotional distress, where what you all recommended, or excuse me, let me correct myself, what you all offered as an idea for public consideration was the removal of caps. There was also some reminders from our members that judges don't, as a matter of course, tell the juries what caps are. So juries perform their action based on jury instructions. The judge awards based on any caps that exist. Andrew and Ian, I'll go to you first. Any background on damage caps, and we're now talking pretty broadly about everything covered within CADA, that you think people should know before we even start offering ideas on what should change, if it should change? What's the current state that members need to be grounded in?
Okay, so this is Ian. I think some of this stuff members have probably heard me say, at least on one or more of our meetings. So prior to 2015, CADA did not have emotional distress damages available for employment claims. So if you had an employment discrimination claim, you could file a lawsuit under CADA and get your job back and get back any lost wages that you might have suffered as a result of the discrimination. And that was it. CADA was amended in 2013 to add emotional distress damages. They went into effect in 2015. And that amendment borrowed from the caps that exist under Title VII of the Civil Rights Act and the ADA, which is a federal statute, 42 U.S.C. Section 1981A. That law was passed in 1991 to amend Title VII to allow for jury trial, because up until that point, you didn't get a jury trial under Title VII. And when Title VII was amended, and so Title VII is the federal law that prohibits discrimination on the basis of pretty much any protected status except disability. When that was added, it also included the ADA, because the ADA was passed a year earlier. The ADA was included within 1981A and set out these caps for the non-economic damages. So what we've been calling emotional distress damages, not wage loss, not the back pay or the money you lost from being fired from your job. And those caps were graduated based on employer size, and Congress decided that employer size would be based on the number of employees an employer had. Those caps went into effect in 1991. They have not changed in the intervening 33 years. And the caps are just, if you have between 15 and 100 employees, $50,000. Between 100 and 200, or 101 and 200, $100,000. 201 and 500, it's 200,000, and over 500, it's 300,000. As we've talked about as a committee, these caps are they only apply in the employment context, and they're based on the number of employees a business has, not anything else. Why these caps were included, I really don't have an answer. This happened at a time historically, when what's referred to as tort reform was going on, and was something that was really part of a big move started in the mid to late 80s at state level, which was really, I think it was I'm going to editorialize a little bit, but it was led by the insurance industry and doctors groups in particular, trying to limit their liability for, potentially medical malpractice. I don't know if that's why these caps were put into place. There are no damages caps under other federal civil rights statutes. Section 1983, for example, what a lot of people might have heard of is the federal law that allows you to bring a lawsuit when the government violates your constitutional rights. There are no damages caps under 1983. Section 1981 is a post-Civil War statute that prohibits race discrimination, and there are no damages caps under Section 1981. So I can't give anybody any more information about why the caps are included other than they were included, and they've never been adjusted. They've never been updated. There was a bill introduced in the House, I don't know, within the last 2 months, called the Equal Remedies Act, which is proposing to get rid of the cap under federal law. The likelihood of that going anywhere in our current Congress in an election year is pretty slim, based on my own guesses. But these caps they're just artificial limitations on what damages a jury can award. Because as we've talked about in the past, right, the jury doesn't get instructed as to the existence of the cap. The jury makes a determination of what it thinks the damages ought to be. And if it exceeds the cap, the judge has to reduce the damages to the cap. I am opposed to the idea of cap. I'm opposed to the idea of caps in this case in particular when we talk about, for example, what Andrew has talked about quite a bit, the intentional discrimination, the kind of discrimination that would warrant punitive damages. Punitive damages are included within the cap. So if you're an employer in an employment case and you've got 95 employees, you're subject to a $50,000 damages cap for punitive and emotional distress. But under CADA, if you're a smaller employer, then let's say you have 10 employees, that cap is only $25,000. The smallest cap under CADA is $10,000. for very small employers, just for having less than 5 employees. I got a problem with that from a philosophical and moral approach to this, where, and I've given this example, I think, to this committee. If I slip and fall at Walmart, my damages are capped based on what the state tort law damages cap is, which just went up. And it's like, I want to say it's about $1.5 million. But if I am the victim of intentional discrimination because of my protected status, and I work for a small business, the most I can recover for those non-economic damages is $50,000 or less if it's an even smaller business. And I got a real problem with that because, again, we get back to the issue I talked about earlier, the dignitary harm that's involved here. It's somebody at Walmart didn't do their job mopping the floor that caused me to slip and fall and hurt myself. It's pure negligence. But when somebody discriminates, they are violating the law, and they're doing it intentionally. When they're making decisions to exclude somebody because of a disability, or to not hire somebody because of a disability, or refuse to accommodate somebody's disability in the workplace, they're intentionally making those decisions. And I have a real hard time with the notion that we've crafted a remedial regime that allows those businesses to benefit from these artificial caps that they couldn't benefit from for their pure negligence. So that's sort of the little bit of me on my soapbox. I'll get off my soapbox, and the other thing I'll just add is I can't believe we're talking about numbers that are a generation old when we talk about these damages. And that's that and these dignitary harm issues are the big reasons why I propose just doing away with them.
With that, I think Ian has given us both the background and frankly some of the important framing and context. Your example that if you slip and fall at Walmart, this is what you can do. But if you are intentionally discriminated against, these are the limits on you, I think is the framing so people understand at the most basic level. I think in what you shared and in the previous conversations we've had, it kind of lays out the scope of ideas that you all could put forward. As we did last month, I'm going to encourage you, or at least invite you, to offer parallel ideas. That it may be that we go one or the other. Here's what I'm going to invite you to offer ideas on now is the scope of: 1, should there be caps? 2, if there should be, what should those numbers look like? To Ian's point that they're a generation, if not coming up on a generation and a half or 2 lagging. 3, if they should be different numbers, should head count be the right measure? And to remind you, when we previously talked, you all offered ideas that ranged from keep it at head count, because that's the most empirical, to look at revenue size, to some suggested looking at net profit size. When we looked at all of these, none of them seemed to be perfect. You all brought up points like you could be a small employer making a lot of money. You could be a big employer hiding a lot of your profits in different ways, or just creatively accounting for them. So these different measures you all put out there, it could be headcount, it could be gross revenues, it could be EBITDA, earnings before income tax, or it could be net income, all of which you all also saw potential risk with. So with that obviously complex maze of none of it is perfect, I'll put it to you all of, should there be caps? If there should be, what should those numbers be? And what should be the factors of the respondent, or we're talking about employer or business, what should be the profile of them against which we're measuring? Alana, your hand was up first, jump in.
Thanks, Barrick. Yeah, this is Alana. As I've been thinking about this, because I was initially thinking we can just modernize the caps, but kind of as we've gone through the list, there's no metrics that we've been able to suggest that seem like they would be consistently useful and applicable across a majority of scenarios. So just like kind of first issue is just coming up with a metric that would be good. I think it's very, very difficult. And I don't know that we would necessarily be able to come up with something that's good enough and also simple enough to be used. Also for things like the modernization piece, in a previous lifetime, I did a lot of work with Medicaid and Medicare in a couple different states. And one of my biggest takeaways from that was they would set limits, income limits, whatever, that were very reasonable at the time. And this happened across several different states where I saw how they attempted to make sure those limits would grow with inflation, with cost of living, with all of that. And no matter what they did, it never seemed to grow enough. So it always went out of date. And I'm just going to assume that that would also be an issue here, where we would again have to come up with something fairly complicated or something just that would take a lot of effort to figure out what we could implement in order to make sure any caps that we did decide grew appropriately, so that in a generation our successors aren't having this exact same conversation. And just the more I go through all of this, the more I think, especially if it's not standard for caps elsewhere, we may as well just simplify it across the board and just remove them entirely.
As the meme says, convince me I'm wrong, or that Alana is, or offer another perspective that you may want to share with the public. Andrew, jump in.
Thank you, Barrick. This is Andrew. I completely agree. I mean, I think to the extent that we are trying to simplify the law for people, make it more plain language, and frankly do justice, removing the caps entirely. One, it does away with the artificial, slicing up employers or entities or whatever the case may be by whatever means we choose. That it's never gonna work. And frankly, all it does take is some wise accounting tricks, and next thing you know, whatever number we've chosen to stick things to is zeroed out or whatever the case may be. Also, when we put these sorts of claims to a jury, that's what the jury is there for, is to do the essentially rough justice of determining how much they think this individual should be entitled to based on the facts of this case. And essentially having a cap is a windfall to these employers or other entities, because, the jury says, hey, you may have damaged this person to the tune of $10 million, and suddenly they're getting that cut by, 20, 50, 80%. That's nothing but a windfall for these employers who have already been adjudged to have done something wrong to the extent that they need to pay damages for it. I also think that avoids the difficulties that Alana was just talking about, of making sure that we are keeping up to date with some amount, because the jury living in the society whenever the case is brought is going to know the realities of that society and what the actual dollar is worth at that time. So I think that jury at that time would be the best situated to make that determination. So for all of those reasons, I agree entirely. I think it makes the most sense to get rid of damages caps completely.
Who wants to offer a counter opinion or a parallel idea of how the state might want to approach modernizing dollars or looking at caps? You all might be guiding us down the shortest conversation about how to update caps and modernize dollars. Is there anyone, and I want people to genuinely feel free to play devil's advocate or offer ideas on what, if any, concerns you could see coming from stakeholders about this. And this should in no way be interpreted as me pushing back on the idea. I'm just going to always push you to look at as many perspectives or paths forward as possible. Ian.
Yeah, that's very good, this is Ian. I can give you what the parade of horribles that'll come from stakeholders in the business community are, right? Having uncapped liability is going to put us out of business. Having uncapped liability is going to mean that we have to raise all of our prices in order to, account for the fact that there's going to be uncapped liability. Having caps gives us some certainty in knowing that if somebody does make a mistake, because the business is a fictional entity that is run by the people who work there. And, the shareholders who own the business can't account for a manager's mistake that might, cost the business tens of millions of dollars, but at least we know that if there's a cap, we're not going to have to pay more than $300,000 or a $5,000 fine or whatever the current, state of the cap might be. Those are the sort of the standard arguments that get raised by the business community about these, about the notion of getting rid of caps or increasing caps. That these costs are going to cause businesses to leave the state. People are going to shut down their businesses and not be in business anymore because of too much potential liability. These arguments come up every time there is a proposal to increase protection for marginalized individuals and to increase the potential for redistributing wealth to people who are harmed by those bad acts. They dig in their heels, and those are the arguments that I would expect we would hear from the stakeholders. Of course, discrimination shouldn't be a cost of doing business. I just don't think that I don't give a lot of credence to those arguments. The simple way to avoid these claims is to not discriminate. But I do expect those are the things we'll hear from the stakeholders on that side. And I'll refer to them as business, right? Because it's the employers, it's the landlords, it's the owners of the businesses that are public accommodation. And we'll hear similar things from the government. The government as a stakeholder is a large employer, operates large public accommodations, and we'll hear getting capped because it's gonna impact innovation. It's gonna cause employers to leave the state, et cetera, et cetera. That whole parade of horribles. Every time the minimum wage goes up, we hear the same thing. So that's what I expect we'll hear from the stakeholders on the other side. I don't know that we'll hear any opposition from the disability rights community.
I would raise an eyebrow if we did, Ian. I agree. So I'm going to ask a two-part question, and this comes with the preface, and I want to be very clear. I'm not offering ideas, and I will constantly remind this group that you're here to set the North Star. You're here to be aspirational. There's nothing that will come from your group that somebody else will say that wasn't bold enough. Let me double it up and make it even bigger and bolder. You guys need to be that aspirational voice. With that said, does do any of the objections Ian predicted or framed compel anyone to contemplate offering a parallel idea? And or, given this discussion, are there specific questions if you put forward the idea of removing all caps that you would want to ask stakeholders about, other than the framing questions we have otherwise asked? Tom Wheaton, jump in.
Can everybody hear me now?
We've got you now, Tom. Thanks.
Thank you. Sorry, I'm on my phone at the airport. I apologize for not being here properly at 11:30. I've only listened to Ian, Alana, and Andrew just now. I affirm all of that. I wanted to let everybody know that I affirm the idea of no caps. And I also think that those arguments will probably be true in Ian's, the way he stated. However, I want to let everybody know that one of my roles at the Paralyzed Veterans of America for about 11-year period was being a national parliamentarian. One of the tenets of being a parliamentarian and kind of a fundamental right of people who assemble is an idea called previous notice. And as we've talked about, it's good to have a previous notice that, things will come down the pike. And in a meeting setting, many organizations need a previous notice of 30 days or 60 days or something like that. Homeowner associations, nonprofits have that. In the case that we're talking about here right now, given the ADA, that was passed in 1990. Therefore, about 2 weeks from now, any employer will have a 24-year previous notice on this issue. And I think that's important for us to keep on the record. Ignorance of the law is an issue here. And I think this would put everybody on notice that, like Ian and I think Andrew said, that what carries the day will be a jury or judge based on the merits of that specific issue at that time. And no caps keeps, any language or vernacular or verbiage that's going to go to change with hopefully the Colorado Assembly affirms whatever recommendations we have. It just to see no caps is very clean, concise, and leaves it into other entities. So I'll leave my comments at that. Thank you, everybody.
Thank you, Tom, and appreciate you joining us. I know you're in the middle of traveling. So I will just go back to the group. It sounds like there is pretty broad alignment on putting forward the idea of removing all damage caps rather than looking to modernize dollars. With that being the case, other than what do you see as the strengths or the implications, or what would you like the subcommittee to consider, which are the questions we're asking about all of your other ideas? Are there any other specific questions you would want to ask stakeholders about this idea? Alana, please.
This is Alana. I'm not sure if this is a stakeholder question, but one question that it would be cool if we could get answered, just because we know what the kind of top pushback arguments will be. And since they're all kind of presumably coming from a specific direction, it would be interesting to see if we could see in other cases where states have changed to remove caps for damages such as this, what was the actual economic impact in cases over the next year or two. Just because I think it would be useful to know how much of that pushback is from like an emotional or gut feeling response of like, oh no, something is changing and I don't like it, versus this is something where folks who should probably maybe be making different business decisions are getting like actual much larger impacts, or maybe it's putting people out of business, making no comment on if they should be in business if they're at that point. But I guess focusing on what the actual impact is. That was a very roundabout, but that is the question, I guess.
Appreciate that. And I'll work with the team and see if we can't dig up. We'll look at what, if there are states that have removed caps. And Andrew and Ian, I don't know if you know offhand states where they have, and we'll see what we can dig up on that. We are well ahead of agenda because you guys short-circuited an entire complex conversation about headcount and earnings and revenue by just saying get rid of it. We will write that up. I think it may be that short, get rid of them. We'll probably put some language. Ian, you've helped tremendously with the examples of things that have caps and things that don't. Does anyone want to offer any other thoughts as we put these ideas together? Tom, please.
Well, sorry, my math was incorrect. It's a 34-year previous notice, not 24. My apologies.
Record has been corrected. Ian, were you raising your hand or just swatting a fly? Ian, jump in.
I was raising my hand. Thank you, Greg. This is Ian. I had previously sent you a chart, state by state breakdown of which states have caps. Some states do not have any compensatory damages available. It's a very small minority of states. But by my rough count, as I'm sitting here trying to be engaged, but also count, it looks to be about 30 states do not have caps on compensatory damage. So, I float that as sort of a hey, this is not groundbreaking stuff. If 60% of the states don't have caps, you know, I do agree with Alana. I'd be interested in knowing, you know, if there are states, and I have some resources that I'm happy to reach out to see if there is any data about that. If there are states that did get rid of caps and what happened. You know, I look at this, and one of the things I look at this is look, we all shovel our sidewalks when it snows, in part because we don't want our neighbors to slip and fall on our sidewalk and sue us. Right. And that's why the businesses that we shop at do that as well. And, you know, this goes back to what Tom Wheaton had to say in terms of sort of prior notice, right? If you're aware that this is the climate in which you operate, and this would be the climate in the majority of the states in which you could go do business, you got to plan for that. I guess questions I would be interested in addition to what has happened in states that have gotten rid of these caps, is I'd really be interested in hearing data about what has happened with respect to business in those states, right? If a state has eliminated caps, did businesses flee the way that I have heard the business community here say would happen if more employment protections are provided to employees in protected classes? You know, California does not seem to be lacking for business, and it doesn't have any caps. New York doesn't have any caps. I don't want to just use the coastal blue states, but most of West Virginia doesn't have any caps. So I'd be interested in knowing if do businesses leave when caps go away, or if caps go up, do businesses go under? Because I think it would help, you know, answer that refrain that I expect we'll hear when we say we want to get rid of it.
And maybe what we can do is, and I do have that chart that you sent me in March, and I'm happy to share it back out with the group. We can, at least for background, include and not just the raw numbers. There's this many states with or without, but we can include in the background. Here is a table of the states with and without. I will just, and I'm going to have to noodle on this. I'm a little hesitant to try to find any metric of did it cause businesses to leave, given that the difference between causation, correlation, and other factors, it may be difficult for us to say it caused or it didn't cause, but maybe by even just highlighting where these cases or where the caps exist might be something. And I'm not ruling it out, Ian. I'm just being transparent as I think about it, saying there's a causal relationship. Let me get Cindy in. If there are any members of the public listening on YouTube, now is going to be your chance to get over to the Zoom if you'd like to jump in for public comment. Otherwise, we will pass that. Cindy, did you want to jump into the conversation, please?
Yeah, this is Cindy. So actually, one of a couple of things. One is really a question for Ian with regard to this chart that he's shared with you. Is this simply a listing of states that do or do not have caps, and if they do, what they are? Or does this give a history of states that have gone from having caps to not having caps, or in what year they made this decision? Because what's not clear to me is, were there certain states that previously had them, then they, you know, decided to get rid of them, or they just never had them to begin with? So that's my first question.
Yeah, and I'm looking at the chart, and the chart that I have is simply citing the code and what compensatory damages and punitive damage limits, if any, are in the states.
Yeah, that's all that's on that chart is state by state citation to the anti-discrimination statute. And again, these are employment discrimination statutes. And then whether compensatory damages are available, if there are caps, what caps are, whether punitive damages are available, and if there are any caps on those. Nothing about history.
Okay. Well, this is Cindy, and I think that without some background, it's pretty difficult to, probably even more difficult to draw any kind of conclusions about whether businesses left or impacted by them. And just coming back to Colorado, I mean, my bigger concern is caps or no caps. We don't really know how often judges are considering those. Like, maybe the jury makes a decision and the judge comes back and says, oh, well, there's a cap on this, so we have to make this adjustment. I don't even think we have that data. And I'm concerned that the whole point of having caps, or even looking at this altogether, is to say, what is the impact for somebody who is filing a discrimination complaint? Are we helping make this effective so that we are essentially impacting, when we're making change, we're making it either more effective for people to file complaints and find some way to resolve those? Do these caps make a difference? Because in the end of the day, I agree with all of you. I think we need to do away with them. We have no way to tie them to inflation or anything else. And so even if we set caps today, next year, they're out of date. We know that. But I'm not sure that it's doing much good. The public may think so. The public may think it will affect businesses, but I'm not even sure they're being utilized in the long run.
Thank you, Cindy. Any other thoughts? I'll walk us through next steps in just a minute, but Representative Ortiz, as we laid out the opportunity for members of the exec committee to address the group, beginning, middle, and end, any thoughts on the conversations you've been hearing?
Yeah, I think it's valuable to have the whole list of what states do and don't have caps. I don't like the idea of trying to cause, and I think you're on the money there, Bear, just because it would be very difficult to talk about causation versus correlation. I think it might be useful to talk about what year the caps were removed, if and when they were removed. If we're going to look at data, I think another data point, especially because we're talking about employment here, if it's available, what the unemployment rate for community with a disability is in those states without caps. I think that would be something that's pertinent, but I don't know how readily available data like that is. I know when I try and get housing data for disabled folks here, specifically in the state of Colorado, I can't find it, right? Like, it's very state dependent, and it depends on whether the state invested resources or not in finding out that information. When it comes to finding veteran unemployment rate for Colorado, for example, I can't find it because Colorado has Tabor and it's not spending any extra money to get any extra information that the federal government doesn't mandate. So I think what would be helpful is finding out what states have it, what year they were removed. Other than that, I think it'd be too difficult, because if we're going to talk about what the unemployment rate for disabled folks is, we'd have to have it for all of that data set. And if you don't, then you can't really infer anything from it, right? So I think that's the good starting point to move forward and make better decisions there. It's just my 2 cents. I would also be pushing towards removing caps. I think putting that in the arena of the judges and the jury is why the courts exist, right? That's what it's there for. And since caps being removed in other states, red and blue exists, and there hasn't been a mass exodus of businesses, or I'm assuming that they still have economic activity there, because as far as I know, there's no state that is, that is crashed because caps have been removed, right? So this idea that the sky is going to be falling, we need to take it with a grain of salt, because I think once we have access to that list, we'll see that what has happened more than likely is that there's still business activity that goes on in these states, and a lot of these states do have thriving businesses. What we're doing is removing the excuse to inadvertently or advertently discriminate against community living with a disability when it comes to employment options. So, and I'll just leave it there.
Thank you. Well, with that, despite you guys having a very abbreviated set of options we're going to look at on this, we use the vast majority of the time. We don't have folks for public comment. So I'm happy to, after I give you update on meetings, which I'll bring Carrie in for, and next steps, give everyone a little bit of time back. In terms of next steps, this one is a very simple idea for us to write up. I'll do as I've done before, put it in a Google document in the folder, alert you all that it's there so you can take a look at the language I use. I'll also follow up with a few of you after I've drafted some language around the framing we want to use for the emotional distress damages and some language there. Once that's tightened up, we'll share that with everyone, get that ready to go up on Engage Dora over the next week, and then alert all of you to that being there and asking you to start sharing it with your networks. Otherwise, we will move into a very robust conversation about public accommodations in our next meeting. It will really be the bulk of that conversation, as well as some other topics you all have brought up. You've brought up things, or we'll bring some topics from some of the other subcommittees. We will have a guest joining us who one of the executive committee members introduced us to. And I'll just tee this up so you can be thinking about it. This has to do with accommodations for children. In this case, it was attending summer camps. We had several families looking to send their kids to summer camps who were told that they needed to hire aides because their child had a disability. The camps offered no solutions. When they asked what accommodations would be available, they were told none, nor given explanation. I'm not looking to litigate this case, but it has raised an interesting situation that we wondered if it was the outdoor subcommittee, but as we talked more about it, it seemed to be about accommodations. So we wanted you to hear from this family, get a chance to talk with them, hear what they've also been advocating for, and just let you all consider this as we go into the public accommodations discussion. Welcome any feedback if you want to offer it now or reach out to me, but that would be the plan. Just about 10 minutes with this family to talk about the idea generally. This is just one example of a business and public accommodations. Is this a matter of the rewrite? Is this a matter of enforcement? We'll leave that to you, but that's where we are now. Carrie, when are we together next? I think it's in a few weeks.
We are together next on July 29th from 12 to 2. I'll follow up with a calendar invite for that also. We wanted to try and give you guys as much time between meetings to reflect and provide your thoughts on all the good stuff that Barrick is going to put in that Google Drive for you. We're also going to make sure that we put plain text versions in there, and we'll email that around too.
Any questions or closing remarks for the good of the group? Seeing none, Rep Ortiz, please.
No, I just want to thank everybody for just the wealth of knowledge and experience they bring here. Like I said, this subcommittee is the example for every other subcommittee. This subcommittee is exactly perfect in what it should be doing. This is why I feel like I don't have to say too much or be involved too much. There's just a wealth of experience here. You guys are really hitting issues that are at the heart of the purpose of what the subcommittee was set up for. Keep up the great work. Thank you for volunteering of your time and giving of your talents and your efforts. Nothing but gratitude to you guys. Thank you so much.
I can't and therefore won't attempt to top that. Thank you, Representative Ortiz. Thank you, everyone. We'll see you on the 29th, and I'll be in touch by email between now and then.